And just 1 second, Deputy. You know what? Once people start dropping things, that happens.
Deputy Lotta started it out, right?
Yeah. All right, the court is going to call 2021 CR 11705, State of Texas versus Luis Angel Alvarado. Could I have parties announced for the record for the state,
Jason Garahan, Your Honor.
for the defense? Oh, I'm sorry.
Welcome to state of Texas.
All right.
Scott McClung from Mr. Alvarado.
And are you Luis Alvarado? All right, are both parties ready to proceed, state
Yes, we are, Your Honor.
defense?
Yes, we are.
All right, Deputy Laura, or Deputy Mejia, do we still have a juror who's missing? Thank you. Juror number 69? Okay.
You call?
All right, so I'm being told. All right, so parties, the coordinator has just told me that juror number 69 is on her way up. All right, so the juror is on her way up, so we'll just wait a little bit for the juror.
Thank you.
And Deputy Mejia, if you'll let me know when they arrive. Yes. I'm sorry. All right, thank you. Oh, and everyone, if you could remember to help the court reporter out when you're speaking to someone, if you could not sort of block her view if possible.
Sure.
Thank you. And also remember that your microphones are on at the day tables.
Did you hear that? Don't forget that one. If you want to tell me something.
Mr. McCrum, do you have a writing tablet for your client or do you need one?
No, he has one, but thank you.
No,
She's not here?
Okay, good.
All right. Then, are both parties ready to proceed without juror number, is that 69?
yes. 69.
She hasn't arrived.
All right. So we're going to proceed without juror number 69,
Sorry, that's 69?
69.
69.
Any objections, defense?
No objection, Judge.
Any objections, state?
No, Your Honor.
And if for some reason 69 walks in, I'll allow both parties to question her outside the presence of the other panelists. And you'll be able to bring her up. All right, let's bring them in.
The first row has number. All the way to the end. And then put the chairs are at. Number 2, next to her. Oh, there we go. 3, 4, 5. Number 8, second row on top. Have a seat.
Oh.
Fifteen, 17. Okay, 15's on the first row. Oh, right here on the bench. 22.
Yes.
The next row.
All right, everyone, please be seated. All right, everyone, good afternoon. All right, that's very weak. Everybody should have had lunch or something. Good afternoon, everyone. Oh, okay, I will tell you, that's the best response I've ever had back from a panel. So you guys are starting off great. So I'm Judge Stephanie Boyd. You're in the 187th District Court on the 4th floor. So where are you?
187.
And who's the judge? See how everybody trails off? When you ask them, when everybody starts trailing off on old anxiety, you know, it starts great and then it just trails off. The reason why I asked that question of you all and have you repeat it is because we cannot continue with this process, jury selection, unless everybody is here. And sometimes we'll take a break, and when we take a break, people get lost. And we've had people get lost before and we're waiting for them and the deputy will go find them and they're on another panel. And we're like, no, you're supposed to be in the 187. So a lot of times people will say, well, I was outside waiting and when I looked up, everybody was gone. So if you remember that you're in the 187 district court or either you're with Judge Boyd, wherever you get lost, I'm the only Judge Boyd in the entire courthouse and there's only 187. So you'll be able to tell them that information and they'll be able to help you. So I've introduced myself to you. This case is the state of Texas versus Luis Alvarado. I'm going to have the parties who are involved in this case introduce themselves to you. For the state.
Jason Gear, oh, sorry, go ahead.
Hi, I'm Daniel Escobar.
I'm Jason Gearahan, nice to see you. Okay.
And for the defense.
Hello, I'm Scott McCrum.
And if your client will introduce himself.
Alvarado.
All right, thank you. Does anyone here recognize any of those parties who just introduced themselves to you? All right. And if you need time to look around, I'm going to ask that question again at the end of the information that I give you today. So we have a court reporter to my left. Can you raise your hand? Yes. All right. This is the thing about the court reporter. If she doesn't take it down, it's like it didn't happen. So she is typing down everything that all of us are saying. And I always try to make people's job easy if I can. So this is the way we can make her job easy. One, we only speak one person at a time. She can take 2 and 3 people down at the same time, but it will make her job so much easier if only one person is speaking at a time. You have something in your possession that's very valuable. You may be sitting on it. They are numbers. Could everybody raise your numbers for me? Awesome. So whenever you have something that you would like to say, or if there is some issue that hasn't been covered that you want covered, just raise your number and either one of the attorneys will address you by your number, right? Now, no jury has been able to get this instruction right that I'm about to give you, but I have faith in all of you. So if you're in the jury box, could you raise your card for me? People on this front row, if you could raise your card for me. Keep them raised. All right, so anybody who does not have their card raised, if you're called on, you need to stand when you're speaking because she'll be able to hear. Everybody else, you're okay to remain seated. So if your cards are raised, you can remain seated when you're answering questions. All right, so is everybody going to be able to do that? Nobody's going to forget? Okay. All right, the charge in this case is murder. And I know when people hear that, people are thinking, man, I really wish I would be on the civil side. Maybe I can deal with a car accident or something else. But in order for us to have jury trials, we need jurors. Now, both the defense and the state are going to have a chance to ask questions of you. What I want you to understand is neither the defense or the state can give you what they think are facts in this case. Everything that they discuss with you are hypotheticals. So nothing that they say is going to be about Mr. Alvarado. It's all going to be in the form of hypotheticals. The only way you will learn what each party are saying the facts are is if you're seated on the jury. Does everyone understand?
Yes, ma'am.
Now, I want to talk to you about an indictment. An indictment is whereby cases are brought in felony courts. Has anyone here ever had a traffic ticket? This is where you practice raising your card. All right, we need to look around the people who say they've never had a traffic ticket before. All right, you're not going to get in trouble. All right, so I've only had one traffic ticket in my life and I was exceptionally young. And that was back in the day when you would get a traffic ticket and you would get a piece of paper. They had the traffic ticket book and they tear it off. Now, my understanding, they do it electronically. Well, let's say you get a traffic ticket and maybe it's not recognizing the yield sign, which in San Antonio, people don't know what the yield sign is for. or, so let's say an officer pulls you over and they say that you didn't follow the yield sign and they give you a ticket and you accept the ticket. You're accepting that ticket and receiving that ticket. You're not saying or admitting any guilt whatsoever. That ticket is not an evidence of guilt. This is just that officer saying, hey, I'm saying you didn't follow through with the yield sign. And to address this issue, you need to be in court. And this is the location of the court. This is what you're charged with. And this is where you need to be. So an indictment is that way as well. You cannot consider it as an evidence of guilt or evidence of anything. An indictment is just the document that's used to let people know what they're charged with and where they need to be. Does everyone understand? Is there anyone who will hold it against Mr. Alvarado because he's here by indictment? Okay. Now, I want to talk to you about certain rights people have, and I always age myself when I say this. Has anybody ever seen Mannix, Beretta? Thank you, number 14. Other people are pretending they're not in my age category. But Paper Chase, The Practice, all of these legal shows. Well, in them, they tell you you have a right to remain silent, which basically what that means is anyone who's accused of an offense and they're going to trial, they don't have to get on the witness stand and testify. And there are a whole host of reasons why people may not want to testify. Maybe they stutter. Maybe they're afraid of public speaking. Maybe their defense attorney said, hey, you don't need to testify. There are a whole host of reasons. But in regards to the right to remain silent, if someone chooses not to testify, you cannot consider it or hold it against them at all. In this case, if Mr. Alvarado were to decide not to testify, to remain silent, is there anyone here who would hold that against him? All right, thank you. The other thing I want to talk to you is presumption of innocence. Everybody is presumed to be innocent when they're charged with an offense. So right now, you haven't heard any evidence in this case. You don't know anything about this case. So if somebody were to ask you, as Mr. Alvarado sits here right now, is he guilty or not guilty? Your answer should be not guilty because you haven't heard anything. And so everyone is presumed to be innocent of whatever they're accused of, unless and until the state proves their case, every element beyond a reasonable doubt. Does everyone understand?
Yes.
Now, your next question would probably be, okay, what is proof beyond a reasonable doubt? When I first started practicing, when you graduate from law school, you had to know the definition. I knew it forwards and backwards. I thought I was so great for knowing that because it took a while to memorize it. I had my first trial as a defense attorney, and after I tried that case, there was no longer a definition for proof beyond a reasonable doubt. So there is no definition for it. And when I was a defense attorney, and then when I became a prosecutor, the best way I would describe it to people was by telling them what it's not. So the building that's next door with the green rooftop, that's where they usually handle civil cases. So the burdens of proof over there are preponderance of the evidence, more likely than not. The other burden of proof is clear and convincing evidence. Now, preponderance of the evidence is what people use when it's involving money. If there's a car accident and somebody's trying to prove that this person did, and then this is the amount of money that's owed, it's more likely than not that it happened. Proof beyond a reasonable doubt is a higher burden than that. So proof beyond a reasonable doubt is not a preponderance of the evidence. It's not more likely than not. The other burden they have on the civil side is what's called clear and convincing evidence. Clear and convincing evidence is what is used to terminate someone's parental right, to tell them, you know what, you're not a good parent, and so we're going to take away your rights to their children. That's a high burden. But proof beyond a reasonable doubt is even a higher burden. Proof beyond a reasonable doubt is the highest burden that we have. Does everyone understand? The other thing I want to talk to you about is the phases of a jury trial. In Texas, there are two phases to a jury trial. I'm from Louisiana originally, so we don't have the two phases in this sense. So here, the first phase, people think it's someone is innocent, but that's not really what it is. The first phase is for a jury or a judge to determine whether someone is guilty or not guilty, whether the state has proven its case or not proven its case. That's the first phase of every trial. According to the law, the defendant has to make a decision on if he were found guilty, would he want a jury to decide his punishment or the judge or the court to decide his punishment? When a person who is accused makes a decision, they are not saying, hey, I'm guilty and this is who I want to go to. It's just the law that says you have to make a decision before your trial. Does everyone understand? Is there anyone here who will hold it against Mr. Alvarado? He has decided that if he were found guilty, he would ask that the jurors assess punishment. Is there anyone who has a problem with that? Anyone here who will hold him against that? Okay. The next thing I want to talk to you about is languages. I love languages. As I've told you, I'm originally from Louisiana. So lo and behold, I never envisioned myself being in Texas. So there's only one language I would learn with my thoughts and where I would be right now. I learned French. And then I ended up in Texas. And then I'm like, I should have listened to my friend Tanya, who said, Stephanie, take Spanish with me. I'm like, we're in Louisiana. We're not taking Spanish. So I wish I would have taken Spanish. I'm working on my languages. When I ended up in law school, I was surrounded by people, some people from Europe. They spoke about 6 languages. So mostly I can say the words hurry up in every language. That's all I know. And that's all they taught me. So is there anyone here whose English is not your first language or your primary language? If there is, if you'll raise your card. That is a first. Usually there's someone who says Spanish is my first language. We've had Taiwanese. Oh, wow. All right. Now that we've had some discussion and people have been raising their cards, I know you all probably stood in the hallway or met downstairs. Does anyone know each other than first meeting downstairs? Okay, that's strange too. Usually we have school teachers who have students on the panel, or either we have an ex-wife and a wife. We've had that before. All right, juror number, they got along fine. Juror number 35. You're messing up.
I know juror number 37 because he was a teacher and I was a student last year.
Oh, which school?
Reagan High School. I was a senior last year, so I'm freshman in college this year.
Oh, and where do you attend?
I'm attending SAC.
Oh, wow. I teach at UTSA. Okay. Well, that's great to know. What subject did you take with him? Or should I put him on the spot and see if he remembers you? Do you want me to do that? All right, juror number 37.
Oh, actually his assistant principal.
Ah. Did he ever have to come to the principal's office? All right, thank you. All right, the other thing I want to talk to you about is travel arrangements. Is there anyone here who has a time constraint or some type of traveling plan and you can't switch your tickets to my name, anything of that nature? All right, number 15, you have to turn around. All right, 6, 15, 16, 17. And once I call your card out, you can lower it. 31, 33, 34, 40, 52, 48, 68, and 71. All right, number 6. What is your issue?
We have plans to meet Sunday through next Wednesday.
All right, and where are you going?
4 days.
And I'm assuming going with your children?
Yeah, my college kids are coming.
All right, do your college kids want you to go with them or you're just, it's just you have the money, yeah. All right. You know, I tell all of the people who work here that Now's the time to do spring break with your children while they still want you to come with them. Number 15.
Friday is my son and my husband's birthday, and we're leaving tomorrow to visit my son at his university,
Oh, and where is he?
College Station today.
Well, hey, LSU, welcome to the SEC.
Born in Louisiana.
Yeah, awesome. Maybe we'll have a better year next year. We shall see.
That's
Number 16.
And in 2 weeks, I'll be speaking at a conference in Las Vegas. So next week I am available. But I also work in the emergency department. And so maybe this is not necessarily a travel restriction, but I work random days.
All right, let's back up a little bit because you're speaking a little bit fast. So your first thing is you're going to be gone in 2 weeks to Las Vegas.
Yes.
All right, so what date?
It's going to be the 14th through the 17th. I'm sorry. It is the 21st through the 24th.
21st through 24th. Okay, and then what's the other issue?
The other, not a travel issue, but I work in the emergency department as a physician at UH, and so I work just random days of the week. Our schedules are made a couple months in advance. I don't know if this is the appropriate time to bring this up, but it's difficult for me to get time off.
All right, and what do you do in the emergency?
ER physician.
All right. Whenever you go to parties, do people just come up to you and start trying to get medical advice?
And then will tell me the weirdest things, yes.
Okay. All right. And your trip to Las Vegas, are you going to be at the conferences or are you just pretending you're going to be at the conferences?
So, I'll be speaking for part of it.
Oh, okay. Well, you have to be ready for that and keep it interesting. All right. Number 17.
a spring break with my senior and my sixth grader. We leave Saturday and come back on Tuesday. We're going to Houston and then driving down to Corpus.
Okay. All right. Thank you for letting me know. 31.
March 16th and 9th to Albuquerque to my granddaughter's wedding. I also got appointments all day this Friday and preparation for that.
All right. So Albuquerque, for your granddaughter's wedding, you have part of the purse strings, right?
I'm sorry.
You have part of the purse strings.
What's that?
You're giving gifts, you're,
Oh, yes. Including all the checking.
okay. Thank you. Number 33.
I'm a teacher and I'm on spring break next week and we're going to
All right, so what are you doing in Los Angeles?
we're gonna do Pacific Coast Highway for a 30-year wedding.
Oh, okay, thank you. And I'm sorry, what date you leaving?
The 11th through the 6th.
All right, thank you. Number 34.
Yes, ma'am. My family and I will be traveling from the 10th to the 19th. We're going to San Diego.
Oh, what are you doing in San Diego?
Family vacation.
Oh, wow.
My 4 boys, my wife and I.
I hear it's beautiful. One of my classmates ended up in San Diego and she always wanted me to stop in. She's like, Stephanie, it'll be fun, but I never had any chance. I regret that.
And go Tigers.
Oh, thank you. Number 40.
I am to a teacher as well, so I'm gonna be taking my daughter with my husband, who's also in the military. We're going to New Orleans from the 11th to the 17th.
Okay, see, people always throw in some Louisiana things. Are you really going to New Orleans?
I am going to New Orleans, baby. I need that crawfish.
Okay.
But this was a trip from like 2 months ago because of being teaching and stuff like that. You know, we had some.
Okay, awesome. Thank you. Number 48.
I have my grandmother's funeral on the 10th or 11th of Shepherds.
Oh, I'm sorry to hear that. Thank you for letting me know. Number 52. 52?
March 28th, I'm going for 2 weeks of training followed by 18 months in Egypt
All right. And what training?
for humanitarian services.
All right. And when are you going to Egypt?
Shortly after training.
Okay, I've always wanted to go to Egypt. I may end up seeing you there. All right, and that's March 28th?
Yes.
Okay, thank you. Number 68.
On March 30th, I close on a house and move to Katy, Texas.
And moving where?
To Katy, Texas, just outside Houston.
Oh, I know a couple of people in Katy. Well, congratulations. Number 71.
The week of March 13th, I'm keeping my granddaughter is teaching her great grandfather in El Paso.
Wow. All right, thank you so much. All right, anyone else? I'll see now people think lightning is not striking. So now everybody's like, let me raise my card. 74.
I didn't know, is that far forward? March?
Oh, no, it's, I don't anticipate it going that far, but it's nice to hear the travel that people have planned. We can live vicariously through you. So 70,
March 26th, first, I think grandkids come.
all right, okay, so your grandchildren are coming. Are you gonna let them do things you didn't let your own children do when they were children? Okay. All right, 25.
Yes, I've got a property closing on Thursday, this Thursday,
What time?
10 o'clock.
All right, thank you. 26.
I'm taking vacation from the 15th to the 19th.
Where are you going?
We're supposed to be going to Jamaica Island.
You say supposed to. Do y'all have your tickets?
Sorry?
Do you have everything
Oh, no,
already
that's,
planned?
That's Jamaica Island.
Oh, Jamaica Island. So you're driving? So is this already planned out?
Did you find out? Hope it goes well.
Oh, okay, all right, all right, thank you. 18.
It's not a travel thing, but on March 14th, I have an exam. With my college course. I take evening classes.
What course?
It's a Galen School of Nursing.
Okay. All right, well, the emergency room doctor is right there. He could probably help you. All right, 37.
March 16th to 20th, we go to Lake Charles, Louisiana.
No, see, I don't believe that. Yeah. Okay, okay, I believe you now. 39.
20th to the 24th, I have a vacation. My wife gave me a laundry list, she gave me a few years. I need to do this.
All right, are you gonna get that done though?
Yeah.
Oh, yeah, okay. 42, thank you.
On March 22nd, sorry. I am an administrative judge with the Texas Department of Agriculture and I have a hearing that day.
All right, thank you. 46.
Sorry to raise my card earlier, that was just a client. I'm also a teacher starting the spring break on Friday. My husband and I are celebrating our anniversary. We're going to Laredo to visit his family.
All right, so for your anniversary, you going to Laredo to visit your in-laws?
No, his aunt is only living. We haven't seen her in a year.
Okay, all right, thank you. You tell them you're a good wife. Number 47.
So this is not traveling, so I had a fatal car accident like January 16. So I had an injury on the website, so I'm going almost the other day.
Okay, what date?
January 16.
January 16th?
Yeah.
Oh, if we're here, we're not gonna be here in January.
That's when you had an
Last
accident.
January 16.
Oh. Okay,
So I
I'm
have
sorry,
to
repeat
follow-
that.
I have a follow-up kind of record. I mean, physical therapy almost the other day. And even I drove my car down here, so today is fine, but next couple of weeks.
All right, thank you. 62.
Yeah, my parents are gonna be going out of town this upcoming weekend and I'm gonna watch my grandpa. He's 94 years old.
Okay. Not throw a party while your parents are out of town.
Maybe, we'll see what happens.
All right, number 22.
I guess maybe reverse traveling. We have family coming in next week, out of state, come stay with us and then just show them around all next week. Tomorrow, my baby's real birthday.
Oh, how old is she? Okay, all right, thank you. Tell her I said happy birth month. Number 12.
I don't know. Earlier that my 2-year-old getting sent home from daycare today and I have to pick her up. Because she's sick.
Okay,
So
prosecutor come tomorrow.
Okay. Anyone else? Your card is turned 19.
I have doctor's appointments the 14th, 16th, and 17th.
All right. 13.
I have a job interview on this Thursday
For where?
for HEB.
All right. Thank you. 41.
Yes, ma'am, I have a medical appointment this Thursday at AMC. And I'll bring it up because it took 2 months to get.
Okay. And what time is it?
2:40.
All right. Thank you. Anyone else? 43.
Does St. Patrick's Day count?
Yes. Thank you. All right. 54.
Hi, yes, I don't know if this pertains, like, I started a new job on Monday. So I'm gonna be working at the hospital at University Health, and I have 6 a.m. to 6 p.m. shifts.
All right. You need to talk to the emergency room person. Thank you for letting us know. Is there anyone else? All right. Could I see attorneys forward, please? All right. So everyone, I always say that whatever you do, you need to make sure that you don't leave your heart at home, that you always can be sympathetic and understand other people's issues. We had a jury panel once where one of the jurors' dogs was taken to the emergency room and they wanted permission. Do we do surgery? Do we not do surgery? Do we let your dog die or not? And so I'd let him be excused, and both the defense and the state said, we're fine with you letting him go because this is very important. So with regards to juror number 12, as you all have heard, her daughter is 2 years old. And as you can imagine, when you have a child who's sick, you want to know what's going on. So she's 2, probably can't put all the sentences together, but she's waiting for mom. So I'm going to, with agreement by both parties, juror number 12, we're going to let you go take care of that. So you'll be excused. You're welcome. Yes, but leave your expensive card behind. Thank you. All right, and you all may see people coming from this door and this door. It has absolutely nothing to do with this case. The people who are coming from this door are not reading the sign that says we're in jury trial, do not come through this door. And the people who come through this door are staff who have things for me to sign. And the person sitting to my left, if you'll raise your hand. She is an intern. What is your name?
Mariela Encinas.
All right, does anybody know her? All right, so before I turn it over to the state and to the defense, I am going to tell you all 2 true stories. I always tell jurors, I know coming down for jury trial, it's inconvenient. Right? If people didn't have to come down for jury trials, they prefer not to, because you have to fight downtown because it's downtown. There are so many one-ways downtown. Then you have to fight with parking. Then you have to stand in the hallway and you're waiting. There are so many things that make it inconvenient. But we can't have jury trials without juries. And I always tell jurors that our country doesn't ask a lot of us. You can register to vote. You don't have to register to vote. If you register to vote, nobody's forcing you to vote. They don't have the draft anymore. So unless something changes with the law, you don't have to fight in the military unless you want to be in the military. And somebody always tells me, yeah, we have to pay taxes. Okay, you have to pay taxes. But I always tell the story about my uncle. My uncle grew up in a small town in Louisiana called Grand Cane, Louisiana. Population was extremely small, super intelligent. And so all the teachers would always skip him in class. And of course, his sisters, and of course, my mom was one of his sisters. He was the oldest, so they would always come up behind him. And of course, all the teachers would be like, That's your brother. We're expecting a lot of you because your brother is super intelligent. So while he graduated early, the Vietnam War happened. And he's like, well, they're drafting all the boys in Grand Cane, and there's really not much for me to do here. So he wanted to just go ahead and sign up. So my grandmother had to sign for him to go. And if you can imagine, that's her firstborn child. And she's signing up to send him off to war. And I bring that story up because we don't have the draft anymore. And that was a sacrifice he made. And if you can imagine, a sacrifice my grandmother made, not knowing if he was going to come back or not. He's since passed, but, you know, when you're sending somebody off the war and they're underage and you know they're going to come back. So I always bring that up to jurors because I know it's a sacrifice, but to me, that really is a sacrifice, and your country is not asking that of you anymore. The other story I always tell people is about my friend from law school. I always wanted to be practicing criminal law, always been my passion. And my friend always wanted to do civil. So once you graduated from law school and she's doing civil, I'm doing criminal, you really don't get to spend much time together because usually on the civil side, it's rare if they're in trial. Usually on the criminal side, people are in trial all the time. So she called me one day and she said, Stephanie, let's do lunch. I'm going to be on a jury trial. I'm like, okay. She's like, I'm coming down for jury duty. I'm like, that'll be great. Let's do lunch. So we meet for lunch. And when we're meeting for lunch, she says, jury selection is going fabulous. And I'm like, I've never heard that before. And of course, now I think about that. I'm like, you're not in the 187 with Judge Boyd. How can it be that fabulous? So she tells me that. And I said, what do you mean? She's like, I am not going to get selected for this jury. I'm like, why do you say that? She's like, it's like I'm in law school. I'm on the back. I'm keeping quiet. I'm not saying anything. And so I started laughing and she's like, what's so funny? I said, we are going to be able to have lunch all week because you're going to get selected. So other than raising your card saying, please select me, the easiest way to be on a jury trial is being quiet. And I tell that story because both the state and the defense, this is the only chance they're going to get to talk to you. And they want to know your opinions on certain things. So with that being said, I'm going to turn it over to the state to begin their voir dire. Each side will have 45 minutes to speak to you. State.
Thank you, Judge. Howdy, guys. I'm Jason Garahan. I introduced myself earlier. One, I can see that y'all are all thrilled to be here. I felt like when Judge let number 12 go, everybody just had a sick kid at home. Oh gosh. But anyway, I'd like to just, sort of just go over the charge of murder. I will tell you this, nothing that I say, nothing the defense counsel says, or anybody says right now will be the facts of this case. No evidence of this case is going to be presented to you right now, okay? So keep that in mind. This is just hypotheticals and actually just trying to get a fair and impartial juror for each side, for the state and also for defense and the defendant that's accused in this case, okay? So keep that in mind. Anything that's said is just to get your feelings on it, to make sure you can be fair and impartial. I always like going over the fact that something sort of touched on what the judge said earlier about the right to vote, that you can register to vote, but you aren't made to vote. I like to refer to Thomas Jefferson, one of our founding fathers, stated that the right to sit on a jury of your peer was more important than the right to vote. I mean, that's sort of huge because you always hear about, you'll see it all the time in presidential elections, of course. Vote, make sure you vote, make sure you vote. Please vote, go vote, you need to vote. I don't care who you vote for, but go vote. Well, I don't know how many of y'all were told this morning when you talk to your spouse, significant other, a friend, they're like, go be on a jury panel, sit on the jury panel, be on the jury. How many here talk to somebody about, well, how do I get out of being on a jury? Anybody? Is anybody outside? I see some smiling faces out there, right? 59. So the fact is that, just remember this, is that what Thomas Jefferson said about the right to sit on a jury, It's that important. It's more important than the right to vote. So that's where we're at right at this particular point. And also I'd like to touch on the fact that sometimes you're gonna see me laugh, enjoy myself. This is my job. This is what I do for my life, my livelihood. Daniel does it, Mr. McCrum does it. I've known Scott McCrum for years. Even though we might be making light of some situations or joking around, we know the gravity of the situation. This is a murder. It's not a laughing matter. Somebody has lost their life. So I take that to heart, and I'm here to protect you just as much as I'm here to protect this person that's accused of murder, okay? Because justice shall prevail. That's what we're out for. As a prosecutor, I'm not seeking a guilty. I'm seeking justice. And if I don't do my job, you go back to that jury room, you come back out and say it's a not guilty because you didn't do your job. And I take that to heart. That's important. Now, speaking about what you can talk about. This is your time to talk to me, talk to anybody here. You can raise your hand or just blurt it out. I know that the court reporter will tell me to slow down. If you see your eyes go real big, tell me because I need to slow down because I talk sort of fast sometimes. But this is your time to talk. And like the judge just said, this is your opportunity to speak to us and tell us if you can't be fair and impartial. And I know it's prejudicial, right? In our society, our community, that's a bad word, being prejudiced, right? Well, I like vanilla ice cream more than I like birthday cake. You know, is that a prejudice? Yeah. So that I like better than the other, right? I just don't like birthday cake. So keep that in mind. We need to know if you have a prejudice. We need to know if you can't be impartial. This is your time to say that, because I'll tell you this. If you come over here and you're one of those 12 that are picked and you're sitting here in this box, it's going to be a very awkward situation for you to be able not to say and do what you told the judge and the court that you would do, okay? So in saying that, just remember, anything you say is not going to be bad or good or whatever. It's just for us to get to know you a little bit better and so that we can know that you can be fair and impartial. Let's jump into the fact of a murder. And what is a murder? Yes, number 43.
Can you say whether it was young, old, male or female?
I can't say anything about the facts of the particular case. If you get picked, you will be sitting right over there and you will find out everything that we can that we can by law give to you in front of the jury, okay? So no, that's a good question though, okay? But no, at this particular time, we cannot tell you other than just what murder is and what the definition in the state of Texas. And what I like doing is sort of reading, I'm getting at that age where I have to use some glasses. And I like reading there's paragraph A and a paragraph B. And I'll explain that a little bit more, but it's going to be on or about a certain day, the defendant did intentionally and knowingly cause the death of an individual, namely a victim, thereafter referred to as complainant by shooting the complainant with a deadly weapon, namely a firearm. Okay, that's paragraph A. Don't memorize that. I'm just telling you so that you sort of get an understanding of what it is. You don't have to memorize anything I say right now. So paragraph B would read, on or about a certain day, the defendant, with intent to cause serious bodily injury to an individual, namely a victim, hereinafter referred to as a complainant, did commit an act clearly dangerous to human life that caused the death of that victim by shooting the complainant with a deadly weapon, namely a firearm. A lot of words. It's a lot of things in there, right? What I'll tell you this, if you're picked as a juror, one of the 12, 6 of you can come back and say, paragraph A is what I believe happened. The other 6 can come back and say paragraph B is what happened, but both of them are murder. You have to unanimously agree on the fact that it was a murder. So it can't be 11-1, 11 for guilty, 1 for not guilty, or vice versa. Okay, so keep that in mind. Now, also the elements of the case. I told you those 2 paragraphs of murder. The elements are things like the defendant, the victim. We have to prove who those people were, the ID of the defendant. We have to prove that it happened in Bexar County, Texas. We have to prove that it was a shooting. In one case, a shooting, and it was done with this the firearm, the deadly weapon. Now, just as important as, say, the victim's name or the defendant's name is also the fact that this happened on a certain date, on or about, say, March 7th, 2023, okay? That's important. We got to prove that date up. We also got to prove Bear County, Texas. That's just as important as anything else. Those are elements of the case. So keep that in mind. That is something that we have to prove beyond a reasonable doubt. And we tell you all these specific things that we need to tell you, then all of a sudden we tell you, we're not going to give you a definition of beyond a reasonable doubt. There is no definition of beyond a reasonable doubt in the state of Texas, as the judge mentioned, but you can.
Jason, she's saying you're speaking too fast.
Oh, sorry. I got a reprimand already, so I apologize for that. Beyond reasonable doubt is not defined. You just use your own common sense and your own reasonableness to determine what beyond a reasonable doubt is to you, okay? By proving these elements, let me ask, just start over here. What I like to call this is sort of like the splash zone. You ever been to the SeaWorld? The first 3 rows are named splash zone. Y'all are 1 through 12, well, 1 through 16, I think, or so. Okay, so the fact is, y'all, this is beginning right through here, and then going back, and then it goes back here. Okay, so splash zone. That means that y'all are some of the ones that will be questioned the most. Some of you way in the back over there, please don't fall asleep, but we'll be talking to you too. But a lot of times we get through a large panel, but a lot of times I call the splash zone because this is where y'all are going to be. Y'all are number ones, I guess you could call it. What type of evidence, number one, would you feel that would come into a jury trial? Any jury trial for that matter.
Physical evidence.
Physical evidence, okay. Number 2.
Surveillance.
So what?
Surveillance.
Okay. Number 3.
I would agree. Physical.
Physical evidence. Number 4.
Witnesses.
Witnesses. Okay, there we go. Finally, after I don't know about y'all. No. I'm kidding. But number 3, yeah, witnesses, right? You're gonna have different types of witnesses, right? Witnesses, okay. What type of witnesses? What's that? Okay, you're number 7, eyewitnesses, right? That's 1. Number 6, expert testimony for like maybe a doctor or something like that, right? Especially in a murder trial, right? You're gonna need somebody to say, hey, we have this victim that is deceased, right? So those are some of the people that might be coming in. Let's hit on the lay witnesses though, and eyewitnesses. Sometimes crimes happen where? Let's go up to what's your number? Number 8. Sometimes crimes happen where? Can happen anywhere, but where can crimes happen? I'm sorry, you're gonna have to speak up so that she can hear. Home, okay. Number 9.
Parking lot.
Parking lot, right? And number 10.
Crowded places.
Crowded places too, where you would have a lot of witnesses, right? Opposed to a parking lot at times. If at times it's a late night, you're going somewhere, you walk outside, you're walking to that parking lot, you're looking around, there's hardly any lights, and there's nobody else around, right? So that's a scenario. Other times, maybe, well, I used to use the term shopping mall. Those are not as prevalent as anymore. Yeah, everybody does it Amazon.com, right? So, but you used to go to North Star and there'd be a ton of people around. So that's where crimes can happen. Crimes can happen in a lot of different places. There could be a lot of different type of eyewitnesses, right? But at times, crimes happen in an atmosphere of, say, not the best part of town or the best place, right? So if it's a place like that, what type of witnesses do you sometimes have? What?
Unreliable.
Unreliable, okay. Well, I mean, is it usually a nun or a priest? A lot of times you don't have that nun, that priest that comes in, is like, oh, I saw it all, it happened in broad daylight, and this is what happened. A lot of times you have people that are sort of in that atmosphere, in that community of where this crime could happen, okay? And you have people like prostitutes. We have drug users. You have individuals that aren't probably the highest standing of character, okay? So you have many different type of eyewitnesses out there that can possibly be there. And I'm sorry, what's your number? 13. 13? If somebody just had a criminal record, would you discount everything they said? No, and why is that? Your opinion matters. And what would help you see that they had some credibility to say what they told you if they took the stand? Okay. Depending on the situation, I like how you say that, because depending on the situation. And what I like describing sometimes is it's like a puzzle, right? I don't like puzzles that much, really, in all honesty. Okay, puzzles, I'm not gonna go into that. That would be a little bunny trail. However, any of those puzzles that you see, like they have like 5,000 pieces, right? And I mean, it's a kitty, right? It's a kitty. And you know it's a kitty because you saw the box. So you know what's going to be, right? However, let's just say you don't have the box, you just have the pieces. And you're putting the puzzle together. And out of those, say, 1,000 pieces, you're missing like 10 of them. Who thinks that you're not going to be able to see that it's a kitty? Anybody? You're going to be missing some pieces, okay? Every trial that I've ever participated in, I think almost anybody's ever participated in, there's missing pieces. But in the end, that doesn't mean you can't see the end result and what really happens. Remember that. There's going to be open-ended things that don't get solved, meaning pieces of the puzzle are going to be missing. However, that doesn't mean you can't see what happened. You can't see beyond a reasonable doubt. Is anybody here saying, look, I need every single piece? If I don't have every single piece of that 1,000-piece puzzle, that's not going to be good enough for me. Anybody here? Number two? Okay. You feel like you need everything. Okay. Anybody else? In the first row, second row?
Will you get me dismissed?
I can tell you a lot of things that get you dismissed. Okay. Anybody else in this row right here? Good question. If there's a 1,000-piece puzzle and with 10 pieces missing, you feel like you have to have every single piece to see what it is? Or do you feel like, hey, you're missing 10 pieces out of 1,000 pieces. I'm going to be able to determine that it's a kitty cat or something like that. All right, you're okay with that? Okay, second row, number 10.
It depends on what, is the kitty cat really small and are all like half the pieces missing from that?
Right, exactly. And in the end, you get to determine that. Because we bring in evidence and you determine which pieces are missing that you can determine. Okay? I mean, but that's a very, very good point, because those 10 pieces could be the kitty itself, right? Okay, second row, third row, 35.
We want to make a statement.
Yes, sir. Go right ahead.
I would say that it also depends on how you stack the pieces.
Right.
Because the way you form it could make it look like that. Or if you change the way you place the pieces down, it could make it look like something.
Like you put the pieces in the wrong spot. Okay. Right. Number 40.
Well, that's something I've taught students constantly making inferences, and I watched the whole entire story change because of your inferences.
I'm sorry, ma'am.
All right.
I'm sorry.
Can't talk that fast. Please stand up. Yeah, there we go.
Repeat your answer, please.
Sorry, I was saying, teaching that, making inferences, I watched the whole entire story completely change. And, the missing piece of itself. So we talk about, yes, 1,000 pieces, not missing everything. Your inference, your opinion can completely change or completely misconstrued your own ideas of what you think or not.
Exactly right.
Just 10 pieces, I don't see like, I would need more,
Okay.
Missing pieces are missing pieces.
All right. Thank you. Number 40, correct?
Yes.
Yeah, thank you. I saw another number back here on that same row. No.
Yeah, no, I read one, but you pretty much covered, to assume
All right, so, yeah,
Oh, number 43.
yes,
Okay,
I'm sorry, yeah.
Go ahead. Okay, thank you.
To assume innocence or guilt without all the pieces, it's hard to judge that.
Right.
So, you kind of need all the pieces to fit together.
Right. Okay. And I mean, let me touch on that real quick. All the pieces, right? If you had all the pieces, what do you think you are? Number 28. An eyewitness, right? So we're not gonna, but I understand the concept. I'm not picking the 48.
If I
Yeah,
may.
go ahead, sir.
Eyewitnesses, in a situation like that, people think they see things they didn't really see.
Yeah.
And over time, their story can change.
Mhm.
So it's really hard to defend because it is a traumatic experience.
Right. I agree, with you. Definitely, especially murder, right?
Yes.
Yeah. I mean, what can help with that? What can help shore up something like that? Number 35, if you don't mind standing, sorry, yeah.
If there's actually like some type of video recording
Okay.
or security cam to help shore up what the eyewitness is saying.
Right, exactly right. That, I mean, everybody wants videos now. Who doesn't want a video? I would cut you right now. I'll be like, you're lying, no. Okay, so yes, video, other additional evidence helps with that, right? And you know, with this puzzle pieces, I am being a little extreme with it, okay? I do extreme things during board hour because that's why we need those extremes. And so I'm not attacking you. I hope you don't feel attacked on that 43. But the fact is I'm not attacking anybody, but I need the extremes. Because there's some people that, well, I'm not gonna say what I think like a squirrel. They don't know, they can't make a decision, right? A squirrel goes this way. And then you see it run across the road, then it's about to get across the road, and all of a sudden you're about to come up on, and you're driving, then poof, it goes back in front of you. You're slamming on your brakes and you're freaking out.
Jason.
Oh, I'm talking really fast. Sorry about that. Sorry. Next to yelling, I apologize. I get excited and then all of a sudden I act like a squirrel. So, but going back to those 1,000-piece puzzles, anybody, I saw somebody raising their hands back there or raising their card. Anybody in this next row or the last row? No? Okay, over here. First row, second row, third row. Okay, all right. All right, so, and speaking about that now, I think we touched on, number 27. Oh,
I was just gonna reiterate on the missing puzzle pieces.
yes, ma'am.
If you came to one conclusion without the 10 pieces, like say he was innocent without the whole 10 pieces, and then in those missing 10 pieces, there was the outcome was totally different.
Mhm.
Somebody's gonna get off wrongfully.
Right,
So
right.
I think you do need the whole.
Need all the pieces in your
Yes.
cat. Okay,
Yes.
okay, that's fair. That's fair. Because I like how y'all sort of messed with my little analogy here because about the puzzles, because you know, if all the puzzle pieces are in one spot, you're missing that little spot, right? That's the jury. That's your job. You get to determine if those pieces are missing and determine whether they're important enough that, hey, you got missing pieces that this case is not beyond a reasonable doubt for me as a juror. That's your job as a juror. Exactly. Point proven right there. Okay. We did touch on the credibility of witnesses. Does everybody feel they could judge somebody that came in, sat up here and testified? Does everybody believe they can do that? Some people can't judge people. Some people can't sit on in judgment of somebody else for either ethical or moral or for religious reasons. Does anybody here feel they can sit in judgment of somebody else? Yes, thank you. We touched on some other things, which is evidence. Other evidence. Somebody brought number 35 brought up videos. Give me some more evidence. Let's just go with number 11.
Audio, like
Audio.
audio recordings.
Okay, so like well, what they're doing with us right now, they're recording what we're talking about or saying, and maybe not. She's typing it down, but audio is right here. There's some speakers or some microphones. So you're saying audio, okay? Like a telephone call or something like that. Okay, number 14. DNA and fingerprints. All right, number 16.
I was gonna say autopsy.
Autopsy. Well, in a murder case, you're definitely correct. That's exactly right. Number
I was gonna say exact same thing.
18, 19, saying the exact same thing as DNA analysis and stuff. Number 27.
In the case of it is a shooting, what type of firearm is it?
What type of firearm? I mean, it could be, you know, a rifle, it could be a handgun, it could be a shotgun, all type of different handguns or rifles and everything out there, right? Okay, number 35.
Any type of trace evidence.
Trace evidence. And it sounds like you might know what you're talking about. What do you mean by trace evidence?
It is any evidence that can be lost within a certain amount of time
Mhm.
after any type of crime has been committed.
Okay,
Such
so,
as footprints and like fabric fibers.
Okay.
and anything along
All right, I got a Dateline guy. You watch Dateline. Don't you? Yeah, okay.
I took an entire class to with friends.
All right, there you go. I knew it was something. Thank you, number 35. Number 28,
So geographical evidence, like soil,
soil.
things like that,
Mhm.
based on the destination that way they can pinpoint where it happened and stuff, or if it was moved.
Exactly. Well, like somebody gets killed in a field that has some red pointy dirt, they put it in the trunk, and then in the back of that trunk, they find it later, and they find that red dirt, they match it to that field about 25 miles away at somebody's farm, like the Murtaugh farm up in South Carolina, and then it goes all. Sorry. I'm sorry. I watched Dateline too. I saw a number back there. Which one? Number 51.
Yes, data.
GPS data, right, from like telephone or a car.
I'm sorry?
You can check GPS by finding pictures.
If somebody takes a picture or, it goes to that GPS location, right? Okay, thank you. Number, is anybody else back there? No, anybody over here? Number 66.
Bank statements or any kind of like transaction history.
Okay, exactly right.
Is there anything related to that?
Okay. And I mean, that's all part of the puzzle. Oh, number 10.
Phone records, computer records, internet history.
Mhm. Those are exactly everything that y'all just mentioned is all part of the pieces. Those puzzle pieces, right? Are those puzzle pieces that add to that puzzle. And when you get down to it. So keep that in mind. There's a lot of different types of evidence that can be out there. I mean, you have people that will testify, you have possibly DNA, you possibly have trace evidence, which many different types of trace evidence. And then you also have the weapon that may have been used, knife, or what type of gun was it? I mean, what does a gun usually leave? A lot of times you watch TV and it's not a cowboy gun. Number 27, what is? There's also gunshot residue, and gunshot residue is something that is left on somebody's hands or something like that, or clothes. Number 11. What's that? The casing, the shell casings, right? Come out of a gun, they end up on the ground or somewhere, and they're found and they're collected, right? Number 10.
The bullet itself, whether in the victim or in the surrounding area.
Number 10. So like the bullet itself that comes out of the gun, it's not the shell casing, but it's just the lead. Okay, number 10. Number 35.
Matching a bullet, I think rifle,
Mhm.
where the bullet rifle barrel has a certain spin.
Right.
So then the bullet can actually.
Yeah, because everybody's seen that, right? Everybody's seen where you can actually take the bullet and there's variations on that bullet. You can match it up to a particular firearm. What happens if you don't have the firearm? Anyone? Number 51.
You could trace trajectory.
Trace trajectory. That's possibly one of the things. But like, if you don't have the weapon, and tell me, let me ask this. Why, if somebody murdered somebody, why would you not have the murder weapon? Number, let's see, what number are you?
21.
21. Why would I not have the murder weapon?
If you murdered someone, you get rid of weapon.
You get rid of it, right? I mean, you get rid of the evidence, right? I mean, I'm not gonna ask if you murdered somebody, but if you murder somebody, you get rid of the evidence. You're gonna hide the evidence, right? Number 18.
The serial number can get back to you.
Serial number could come back to you. Things like that. I mean, that's another piece of that puzzle. By somebody getting rid of a murder weapon, would that be one of the, maybe a puzzle piece? That'd be another piece of that puzzle? Would everybody agree with that? Yeah. So those are particular other evidence that you can look for in a case, right? And those are puzzle pieces that would be added to that puzzle. Obviously, we have other types of evidence out there, lots of other photos, possibly diagrams. I think you mentioned autopsy. There's all those puzzle pieces that are out there. And in the end, you get to determine whether all that evidence, including testimony, is credible. And whether we prove as a state beyond a reasonable doubt that the individual committed murder. Okay, now let's talk about possible defenses to murder. Let's go with, who have I not, number 20? Okay, sorry. You don't have to hold it the whole time. I should be looking at my diagram here. Number 20, what possible defenses would be, what do you think would be presented possibly by, what would be a defense to murder?
Accidental.
Accidental, right? I didn't mean to do it. The gun went off and it just happened, right? Okay, number 18. Self-defense. That's a big one. That's a big one, right? Everybody hears about self-defense, right? Self-defense. Does anybody know the definition of self-defense in the state of Texas? Anybody?
Not by the state of Texas.
What's that?
Not by the state of Texas.
Well, luckily I have a statute here, all right? And I'll tell you this, is that this is the definition of the state of Texas. It's section 9.31, self-defense. And it says, except provided by section B, a person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. The actor's belief that the force was immediately necessary, as described by the subsection, and presumed to be reasonable if the actor, and it says several other things that you will get in front of at a jury charge if that comes up. So it's a sort of a legalese stuff, right? It's sort of like, okay, everybody's sort of, Tell me this. I like using examples. And so if I have a knife and I start running at Daniel, my co-counsel, and I'm coming up to him like this, and he shoots me. Number 4, is that self-defense?
I would say so,
And why?
because he was attempting to do him harm.
I was attempting to do him harm. Deadly harm, right? Because that was matching my force, my deadly force, right? Because a knife is what? A knife can be used as what? Number 19. To cut stuff up, to cut a human up, right? You've seen and heard about murders that happened where a knife is used, right? And if I have a knife that's can be used as a deadly weapon, and I'm approaching him, he can use deadly force to defend himself, right? Most people agree with that. Everybody agree with that? Number 46.
Yeah, maybe he just feared for his life, so.
He feared for his life. And you mean by what? Let me say this. What if I walk all the way over here? I have a knife in my hand. I yell at Daniel, "I'm going to kill you," and he shoots me. What's that? Number 43? That's wrong. Why is that wrong?
Because you didn't approach him.
Yeah. Is it immediately necessary for him to defend himself with deadly force? That's important, right? It's what the actor, or rather, what the person's acting in self-defense believes, though. So if he's over here, I'm over there. Let me tell you this. What if I start running at him from back there? I trip and fall. I drop my knife. I look at him. I go, "Oh crap," and I run away. He starts chasing me down. No, that's not self-defense. Number 48, if you don't mind standing up.
I'm sorry, ma'am, can you speak up, please?
Sorry.
Whenever they start turning around and running from you, fishing from you. Speak
Okay.
up, I'm sorry.
She said,
As soon as they turn around, it's no longer self-defense because they're running away. Or you can win.
so they're running away, trying to get out of the situation, right? Does everybody agree with that? Number 21.
If Daniel's never shot a gun, he doesn't know if the safety's on. He doesn't know if he's gonna be successful in shooting the gun,
Correct.
then you'd have to give him leeway to shoot sooner.
Shoot sooner. Okay, so like if I'm running towards him with the knife before I trip,
Well, like when you were standing there and you started to come towards him,
Mhm.
you know, like a policeman would say, I can wait till he's within 3 feet of me to shoot.
Mhm.
But Daniel's like, I don't know if the safety's on, I
yeah,
don't know how to aim this thing.
right, right. Well, I mean, what if it's his gun that he's fired over his lifetime? He's had it for,
Yeah, well, then that doesn't.
and that's a factor. That's a puzzle piece, right? You might know that that that's his gun that he's had for a long time and maybe not, right? But those are all factors in determining whether self-defense was appropriately used, right? And in this type, and that type of scenario. So, and I think a number, I'm sorry, what number were you? I'm sorry, 48. What she brought up is once you turn around and you're trying to get away, that's not self-defense anymore, right? Because
Your Honor, I would object using stating the law. It all goes in the reasonable belief of the actor. There's no objective if it's running away, it is or not.
Your Honor, I'm just reiterating what number 48 said.
All right. So ladies and gentlemen, the law will come from the court. States, you may continue.
Thank you. So in a particular case like that, those scenarios. Does anybody else have, I want to see number. I thought it was number 57. You're 59. Oh, 59. I switched around on me. I don't know. 59. Sorry, you're 57. I'll go with 57. That's what I said. What do you believe? Do you believe that the actor is acting reasonable if they shot somebody in the back?
It's all situational.
Situational.
I mean, if it's pitch black dark, you can see that person's running away. And assume that, so if they have another firearm.
What if they have a firearm or something?
Yeah, you just don't know if it's dark. I mean, it's broad daylight, I guess you can make a decision on that, but if it's dark, I mean.
Okay, all right. So let me go with 43. Let's go with 43. Go ahead.
If there's a legitimate threat that might come back another day, I can understand shooting.
Okay.
But usually if they're running away, we'll fight another day.
Right. So, okay. So like you're saying that if they may be coming back the next day to shoot you, it's okay to shoot them in the back.
Oh, I'm not saying it's okay. I'm just saying, if you feel legitimately threatened and you may not be prepared for them the next day, sometimes you have to shoot.
Okay. All right. Number 23, 22. Sorry, I started 22. Do you agree with that? Question.
Situation.
Okay.
Maybe like who the person is, what you know about them, or like based on the evidence we gathered from that situation.
Okay.
Kind of like I said, if he feels threatened based on the evidence or experience with that person that short time, maybe he would justify shooting.
Okay. Okay. Number 27.
I disagree with that. If someone's running away and you know that they're fleeing and they're getting out of there, it's now excessive force shooting that person in the back. But if you see them running, grabbing something, then coming back, then I think you can justify shooting them after you see them coming back to us.
Okay. All right. Number 35.
As far as I'm aware, self-defense is you have to use proportional force from the attacker or the defendant.
Right. Right. Thank you. Agreed. Anybody else? Number 13.
What if self-defense turns into defending somebody else?
I'm sorry.
What if self-defense turns into defending somebody else? So say the person who's attacking me is running away, but it's going to go attack somebody else.
Right. I mean, there is self-defense or defense of a third person in the state of Texas. That's also a scenario where I'm running at Daniel with a knife. You see that, you shoot me. That's defense of a third person. Because I mean, remember guys, this isn't a vacuum. There's a lot of other factors that play into it. So I'm not trying to say that this exactly is a scenario that I've been around or heard about or a case tried, but the fact is those are scenarios in a vacuum sort of like where you shoot me because I'm about to attack Daniel. That's defense of a third person, and that's legal in the state of Texas. Number 7.
State 10 minutes.
10 minutes?
Yes.
Thank you, Judge.
I feel that, like, if I was I am a female. And if a larger man were coming towards me and he could choke me, well, I would shoot at him.
Okay. Yeah, all right.
Because that's my only defense. I'm not a large person, I'm a small person.
Okay.
So that, in my opinion, would be.
You know, a scenario I'd like to give you, since you sort of brought that up. Let's just say, I don't know if y'all heard this about the movie theater, where if somebody got mad at somebody else, they threw popcorn at them, and they were just standing there, and the person shot them. Okay, and that's a scenario, that's a scenario, right? Where that person was just yelling at the person, calling them a bitch, an asshole, and other dirty, nasty sort of fighting words, you know, being, in a sense, provoking you. And I'm like, hey, you're a piece of shit, and you're an idiot. And
Nope.
no,
Can't shoot.
does anybody say, hey, you should be able to shoot somebody for just calling you? There'd be a lot of problems out on the highway, probably, right? Number 16.
As we're working in the emergency department, it's a very dangerous environment. I oftentimes, at least once a week, like have to assess if someone is an actual danger or threat to myself or my staff members or other patients. You know, certainly the size of the person can come into account as well. I mean, there's so many different variables that go beyond just like uses, but it can change very quickly from someone being an active threat to somebody versus, you know, if they're amenable to being talked down or if they're amenable to response, then it changes from them being a threat to them being someone who's no longer someone who's a threat.
What? I mean, that's a good scenario. Number 28.
So like in the scenario where someone feels an action threat, and then they would be fleeing, do you think that, even if they were fleeing, to shoot them, like just to get them down, because then if they get away, they could come back.
They could come back.
So not necessarily kill them, but, you know, injure them enough to get them down. Yeah,
If you shoot somebody, what do you think that you're intending them to harm?
yes,
A substantial likelihood of death?
yes.
Okay, so I understand your scenario, but that's sort of that paragraph B. I just wanted to wean them, right? I just shot them in the leg so that they won't bother me again, right? And I've had some murders where somebody got shot in the leg and they died because of that. So that would be considered, you know, in a vacuum, murder, right? That'd be that paragraph B. I just wanted to wing him, but I shot him and because I didn't want him to bother me anymore. Okay. Let's see. You know, there's stepping stones for self-defense. One, it has to be immediately necessary. Can't be words alone, right? We're agreement on that it can't just be words. It can't be this situation where I'm just yelling at you, calling you, you know what, and saying, let's go. Come on, you're a bitch. Let's go. Okay, that can't be the situation, right? Words alone cannot be that. Now, also, I think we've hit on that pause in the action where I drop the knife and I turn around and I walk off or I run away. Is it immediately necessary for me to use force or for that matter, deadly force to protect myself at that point? No, everybody agree with that? Moving on to other additional evidence in these situations. One, I think we've hit on just about any additional evidence we could possibly come up with, right? Does anybody have any additional evidence that you would like to see in a murder trial? Number 71.
I just want to say this kind of hits home of being like shooting and running away. I don't think I'd be a huge asset to either parties. I feel a little biased right now.
Okay.
So explain for that.
Well, I'll ask you bias. Bias as in towards, don't like the prosecution or the state, or don't like a defendant that's accused of it.
Something similar has happened in our home.
In your home, okay, so I'm assuming that you have a prejudice or bias against the defendant? Okay, thank you very much for saying that. That was number 71?
Yeah.
Okay, thank you, ma'am. Let me just hit on, since I'm running out of time real quick, a few minutes, I believe. Remember this, right to a jury trial. Everybody has a right to a jury trial. Just because you might have the evidence, the state has all the evidence and everything else, everybody has a right to a jury trial. And just because they say they want that right to a jury trial, you can't hold that against them. You got to determine the credibility of the testimony that comes in and meet it with beyond a reasonable doubt. And at that point, come back with that guilt or not guilty, okay? And the right to remain silent. Judge hit on this. You don't have to testify as a defendant. You cannot use it against him. And everybody in here said that you would not use it against the defendant if he or she in a particular trial would not testify. So keep that in mind. A lot of the stuff that will not come in during a jury trial are things like sometimes witnesses or history of those individuals, like bad acts before. Those don't come in during the time because they're not relevant for this particular proceedings. During punishment, you may find out about those type of issues or things that are in the past of a defendant or anything of that nature. And I'm glad that number 17 brought this up. Has anybody been involved in, not necessarily, accused or been a party to or a victim of a murder? Or somebody has been murdered that was in your family, or maybe a family member murdered somebody, your friends. Anybody here? Over here, number 2. Family member was murdered?
Yeah, awesome.
Okay. And number 4?
Family member.
Was murdered?
Accused.
Accused of murder. And what happened in that? Were they accused of it?
He was found guilty.
Found guilty. Okay. Would now anybody else in this row? Number 8?
My stepson.
Stepson?
Was a victim.
I'm sorry.
My stepson was a victim. He was murdered.
He was murdered. Okay. Anybody over here? 21?
My father was married.
Your father was murdered. Okay. Number 22?
Maybe not direct, kind of vicariously perhaps, my grandfather was with the FBI. Cases he was on.
Okay.
Some of the Texas, other processes.
Okay.
I like that.
Okay. Thank you. Number 24?
Brother-in-law was murdered.
Your brother-in-law was murdered. Okay. Back here. Number 26?
Cousin.
Cousin was murdered. Okay. Over here, number 59?
My nephew was murdered.
Nephew was murdered. Number 62?
2 of my cousins.
2 of your cousins were murdered. Okay, number 64?
Not murder, but wrongly accused.
Wrongly accused?
Biased
Okay, biased towards the state.
towards the state.
So you don't like the state, you don't like, okay, you don't like football. I like your haircut. though.
Thank you.
Number 53. 2 nephews were murdered. Okay, number 23. That was murdered. Okay. Okay, thank you. Number 16.
For dozens of people have been shot.
Okay, and so you obviously deal with that, all right? Number 20.
I had a cousin that was murdered, but I didn't know him.
Okay. Okay, and you're gonna hit on something I'm about to ask. Number 40.
They're not family members per se, but they're students that I've worked with.
Okay, so in saying that, and
What's her number 40?
number 40, she had students that were lost to gunfire or been shot, rather. Okay. All those individuals that do raise their hands on those, raise their cards, would any of y'all that had said that, did any of y'all feel that because of those experiences that you had with the murder case, would that affect you in a murder case to be able to judge an individual that was accused of murder? Anybody?
Good possibility.
Number 2, number 4, possibly, number 4, and number 8, possibly. Okay, number 22, possibly. Number 24, possibly. Number 40, possibly. 59, possibly. 62, possibly, and 64. 64, you said you did have a bias no matter what. So you felt like you had a bias for the state. You don't like the state. You won't agree with the state no matter what.
Yeah, but I like your haircut.
Thank you. Any other individuals on that one? And now I said possibly. Number 17.
So, don't have a murder, but I have a case going personally where, threats were given to my child and my niece that they were gonna try to kill them. And so I actually had to get like police involved, get Northside police involved for the school
Okay.
to monitor children. Not saying that would, make me have a biased decision, but it could. But
Okay.
I thought you should just be aware.
I appreciate you sharing that. Thank you
All
very
right,
much.
and that's time.
I am about to sit down now. Good. I'm out of time, right?
Yes.
I am. Okay. Thank you all very much for listening to me blab this whole time. I appreciate it. And I'll turn it over to Mr. McCall.
All right, so ladies and gentlemen, I'm gonna give you all a short break. So before you all run, look to your left and look to your right. The people at paper who know paper chase will know what I'm about to say. You are responsible for the person to your left or to your right. So when you all line up outside, make sure the person that you're responsible for is either behind you or in front of you, because we can't start unless everybody's here. And once I give you all your break, it means that everybody has to leave the courtroom. You can leave your belongings in here. No one's going to touch them. Deputies are still here. I'll still be here, but I want to give you all a short restroom break. So I'm going to have you all, if you all can line up back outside by 3:25. Is that enough time for everyone? All right. All right, everyone, please rise for the jurors. Oh, sure. This. I see in the jury box, there are some empty chairs. I said, I see there's an empty chair. Ah, okay. See, I'm testing you guys. Pass the test. All right, everyone, please be seated. All right, everyone, please be seated. And I'm sorry, juror number 1. Yes. Okay. All right. So her question, everybody, was that if you all are selected for as one of the jurors, would you be able to bring bottled water in or something of that nature? And the answer is yes, you would be. I always tell people, just make sure it has a top on it to avoid spillage. So I'm doing my part to try to keep the courtroom clean. So if you all can do that, but yes. And if ever anybody needs a break, just do this. That'll let us know you need a break. And either I will see you, court reporter, or one of the attorneys or the deputies. All right, defense, are you ready to proceed?
Yes, sir. Thank you. Okay, good afternoon. I'm Scott McCrum again. I don't think I'll take too much time. Jason did a good job talking to you guys about really a lot of the issues that come up in trial. One thing he did, though, that I want to pick up on is he asked about bias because of experiences some of y'all may have had in your lives, someone of a victim of this type of offense or someone in your family. And he asked if it was possible that you might have a bias. And several people, about 15, answered and raised their card. But the important thing is that we pretty much have to have a commitment from whoever is going to be able to serve on the jury that you would be able to serve without a bias. So at this point, to say if I might be biased or I might not be the right kind of juror doesn't really do it for us. We need a commitment from all of y'all to say, okay, I can put it aside, or I'm not sure I can put it aside. And so I'm going to ask those of you, please, to dig down and think if it's something that you don't think that you can put aside, then we need to know that. So I don't know if I need to go through all of you individually, but number 2.
Yeah, I said probably, but I would say that it will affect.
It will affect you. Thank you. I appreciate your honesty. You're number 1.
Would more than I thought. I think I would be a little biased.
You think you will, or?
I believe I would.
Okay. Number 4, you raise your.
I did.
Do you think that you could put that aside, or?
I think I don't want to go through another trial. I went through the entire trial with my brother. The evidence was terrible and he still got convicted.
Okay, so you don't think that you could be fair if you were to serve?
I don't think I'd be fair enough. I don't think I can convict anybody.
Okay. Number 8, yes, ma'am.
I don't know if it's a bias, but losing our son, it happened just about a month ago. And so it's really fresh for me and I'm having a hard time not thinking about it.
Yes, ma'am.
All I
I'm
can
sorry to
think-
hear that
It's
you
all I can think
experienced that.
about right now. Thank you. It's all I can think about right now, and I just can imagine that if it's anything related, which we don't know. I don't know that I'd be able to focus and really give the attention, you know. Not really judging the situation, but it's just hard to think of anything else
Yes, ma'am.
other than my situation.
I understand. Thank you. Anyone else? And if y'all don't mind, I'm gonna take it row by row. Was there anyone in this row that had any experiences that you felt would affect your ability? I think you raised your
I
father.
had an experience, but I think I could put that aside. You weigh false accusation against murder, you know, both are a big deal.
Thank you, sir. The next row, yes, sir, number juror 22. You cannot put it aside. Okay. Juror number 23. Okay, thank you. Was, yes, sir, your number 19?
Excuse
Yes,
me.
sir.
I got that.
Hold on just a
Excuse me,
second.
just 1 second. Who is number 19? I thought you said 19. Okay, thank you.
I did, Judge.
I'm sorry, sir, I
You
can't
have to
hear you.
speak up so she can hear you, sir. Okay, so you don't feel that you could be fair? Yes, sir, number 24. No, sir, you can't be fair? Okay, I appreciate your honesty. Nothing wrong with admitting that. Number 16.
And we've had cases sometimes where there's a drunk driver crashes, kills somebody else, and I'm taking care of both the driver and then comforting. Or sorry, the family that was left behind. So it's, I don't know, just, well, I haven't personally had anybody home, seeing those cases, taking care of both families.
I could imagine seeing that on a daily basis, and that kind of trauma and the effect it has on people would affect you, your emotions, and that your emotions would be stirred if you were subjected to a trial and forced to judge it. And I guess I could empathize with that, but the issue is, could you be fair despite those things? Could you put that aside? And even though, and I don't mean to, I don't mean to press you into anything, but it's important enough that even if it's difficult, a juror has a duty to serve. And I'm not, please, I'm not preaching to you at all, but if it's at all possible that you can put something aside, then it's required of you.
I can put aside the bias when it comes to the medical care, but certainly when it comes to just the emotional piece that takes on the stress that it puts on the nurses.
Okay, it's understandable. Thank you, sir. And your number 16. Number 20, yes, ma'am.
Did you say you wanted a commitment from everybody that raised their card before?
Anyone that believes at this point that for whatever reason, you cannot be fair, either to one side or the other. And actually, I mean, we talked about it in the context of having someone in your family that experienced that, or someone close to you. But I'm asking you, I guess if it's for any reason whatsoever. If you're taking a look at Lewis and saying, I just don't like the way he looks, I'm not going to be fair if I get picked as a juror. Or if he's sitting there and you're thinking, man, if he's charged, he must have done something wrong. I can't presume him innocent. If for any reason like that, you just don't feel that you could be a fair juror, that's what I'm asking for. Number 15, yes, ma'am.
I know this is what I'm supposed to be doing, but since I got my jury card, I've had anxiety since. I think I could do this. I don't think I can be fair.
You can't be fair, ma'am?
I don't think I could. I don't think I could sit through it.
Okay, that's a different issue than not being able to be fair? Do you feel physically you would not be able to sit through a trial because of your maybe anxiety and? Okay, all right, thank you, man. Did we go through the second row? Anyone else? Third row? Next row? Juror number 40. Yes, ma'am.
I know it's my duty, but as I've been sitting here, I just don't know how I could be there. And this is.
I think I know what you're saying, but the words you said were, I don't think I could be. You can't be. Okay, thank you. Thank you, miss. I appreciate you letting me know. Anyone else on this side? What about on this side of the room? Number 64, I think you already mentioned that you couldn't.
Yeah.
62, could not be fair. 62.
Thank you.
Number 71, I think you mentioned that you could not be fair. Appreciate that. Now, speaking on this, this is the regarding the presumption of innocence. And that's why it's so important for y'all to be honest about coming into this and being able to be fair and unbiased and putting those feelings aside. Because we all have feelings about serious issues like crime or things that we've experienced, how we want our communities to be free of this stuff. We all might feel looking up here that he must have done something wrong, or why is he sitting here if he's presumed innocent? And it's okay to feel those things. That's just natural to feel that. What's important though is to be able, like I said earlier, to put it aside. Is jurors have to be able to put those feelings aside. And an example of that is, I hope Your Honor doesn't mind me saying this, but in a trial, jurors will be the judges of fact. You'll hear all the issues. For example, Jason talked about how maybe some scenarios would play out in a case of a murder or an assault and self-defense, and jurors would have to listen to it and listen to the facts that are presented to them. They'll have to decide whether they believe certain facts or disbelieve certain facts and come up with what the jury feels happened, the facts. And you'll be the judge of the facts. What Judge Boyd does is she is the judge of the law. She decides what law is applied in a case. She makes sure that us as the attorneys are doing things according to the law, introducing evidence, making objections, soliciting testimony. She makes sure the order of the court is followed. And that is her job. That is her role, to be a judge of the law. The example I like to give people is she deals with us lawyers on a daily basis every single day. And all of us obviously are different. Some of us probably are a lot more annoying to her than others.
No.
Some of us are, some lawyers might try to push the boundaries of what they should get away with. Some might be rude. Lawyers are different, just like anybody else. You have different peoples and different personalities. And because of that, judge might, aside from being on the bench, personally have certain feelings about some lawyers versus others. But when she takes the bench and puts her robe on, she puts those feelings aside. She treats every lawyer who comes in front of her the same because that's her job. She makes rulings according to the law, no matter who the lawyer is, and no matter what her personal feelings might be about that lawyer. And she does it every single day. So even though there may be some people who strike more emotions from her if she has feelings about them, for the most part, it's probably second nature to her. Is once she puts the robe on and takes the bench, everyone gets treated equally because she does it every day. Jurors don't do that every day. I've always thought to myself that I feel jurors, when they're asked to serve on a jury, should be given robes to wear. I really think the 12 citizens should be in robes up there because that's how important it is, that role of being a juror, to be fair and impartial. But it's not easy and it's not natural. And I appreciate those people who spoke up to say, I wouldn't be able to do it. I don't think I could do it. But for our system to work, it requires that, because our system of justice, we have in this country, we have a goal of a 0% error rate. We don't ever want to get it wrong. In all these trials across the country, across the city, across every state, misdemeanors, felonies, capital murders, misdemeanor thefts, we want to get it right on every single one. That is a great thing about our country. A lot of things our country is going through that maybe we're still working our way through, but we can all take pride that as far as our criminal justice system, we want 0% error rate. And that's on both sides. Members of the community, we do not want people who committed a crime to get away with it. We don't want people who are guilty to walk out of here and for whatever reason, not be held accountable. We all want that. On the other side of it, though, is we don't want people who are not guilty to be wrongly convicted. That's the worst thing in the world, to think of some people who go to prison, are convicted, and are found later to be not guilty. How many people have heard of the Innocence Project? What is the Innocence Project?
I think they're students primarily, and also young lawyers and obviously some mentors who are using DNA evidence primarily to exonerate people who were previously found guilty of murder.
That's right, or any offense. But for the most part, and like you said, it's when people are found guilty and they're sent to prison, and on average, they serve more than 10-year sentence before they're found to be not guilty. To actually be found not guilty and exonerated, usually by DNA evidence, because that's the only really definitive way that you can go in and say, no, that person really was innocent. You can't really do that with maybe other new evidence, maybe a witness is changing their mind or something, but usually it's DNA that ends up clearing people. And that's, I think we can all agree, that's a horrible thing for people, if you think about their lives, to have been sent away, gone to prison, served over 10 years, 15 years, what have you, when they were not guilty of the offense. Why do you think, who have we not heard from? What is your number, sir? Number 5. Sir, with as careful as we are to do things right, like I said, to get it right, have presumption of innocence beyond a reasonable doubt, that we still have those cases fall through the cracks where innocent people are wrongly convicted. How do you think that happens?
It's hard to say. Get the answer.
Can we come back to you?
Yeah.
All right. Anyone else? Number 10. Yes, sir. What are your feelings about that?
That's due to jurors who aren't sure if they can be biased or not, but don't speak up about it.
Could it be maybe juror or jurors end up on a panel and they didn't look at things objectively, right? Number 14.
They had a 1,000-piece puzzle and this is missing.
I didn't even think of that. Very nice. Thank you. Number 27.
Evidence could have deteriorated, or eyewitness could say one thing and then it turned out to be not true.
And why would an eyewitness say something that turns out to not be true?
They could change their minds. The panic of being on a witness stand could get to them, or they could just change their story, because we don't know why they would change their story, but they could.
Maybe a witness got up and testified and they were just mistaken about what they saw and sounded convincing enough to convince a jury in that. Or on the other hand, get up on the witness stand and maybe intentionally lie about something, but be convincing enough to convince a jury of something. Number 43.
I mean, somebody, just due to stereotype, somebody could think that they saw something just because of the person that they saw doing it.
and be wrong, end up that they were wrong about it.
Yes, sir.
Yes, ma'am, 68?
A lack of direct or circumstantial evidence.
I'm sorry?
A lack of evidence.
Being forced to make a decision on circumstantial evidence, like you said, not enough direct evidence, and just maybe just getting it wrong. Right? I mean, I can tell you, well, let me, first, number 35, you wanted to.
One of the books that was turned into a movie, like, called The 12 Angry Men. One of the things that went over was the way the evidence is presented.
What do you mean?
If the evidence isn't presented in the right manner, it would not be able to help convince the jury to see the evidence in a different way and how it all falls into place.
Okay, and so it was, the jury was not given the ability to see everything as it truly occurred?
In the book, the defense was not able to present the evidence in a good way where it was 11 out of the 12 jurors automatically walked in with guilty, but the one juror who walked in wanted to go over all the evidence to make sure everybody had no like unreasonable doubt in their mind.
And the others wanted to get home.
Others wanted to go straight home.
They thought they had seen enough.
Yes,
Oh, thank you.
I would definitely recommend that.
I've seen it, and I believe that those jurors, they didn't believe they were wrong, right? They thought they were right, and they weren't. I can tell you, I've been doing this a long time, a lot of years. I've had a lot of trials, and every trial that I have been in, I have walked out feeling that the jurors tried to do the best that they could. They really embraced their role. Always. I many times walked away not agreeing with them. But I always felt that they were doing what they felt was right. But it's difficult. It's difficult because Jason mentioned earlier, he talked about, well, if you knew everything and you saw anything, you'd be an eyewitness. It's difficult because as jurors, you're not eyewitnesses. All you have is what's going to be given to you. And it's a tremendous responsibility to get to that 0% error rate that we would like you to have. We want you to get it right. And so that's why it's so important. Number one, to go in, that's what the presumption of innocence means, is that we all have feelings one way or the other, but once you put on that robe like the judge does every day, you put those aside. And you look at things as they are and not what maybe you would perceive them to be based on any biases or prejudice. The other thing that protects our system is the burden of proof beyond a reasonable doubt. It's a tremendously high burden. It's often, a lot of times you'll hear, well, just use your common sense, just be reasonable. But it's, yeah, you have to use your common sense, but you have to use your common sense to hold the state to the burden that there is no doubt whatsoever that he committed the offense based on reason. If there's any other reasonable explanation other than what they are trying to present to you, well, then it would be not guilty. And that's a tremendously high burden. I think a lot of times what happens when maybe we talked about the Innocence Project and some people are wrongly convicted, and it's on cases like murder, sexual assaults. Because obviously if they're serving 10, 15, 20, 30-year sentences, it's because they were for bad offenses. And those stir a lot of emotion. You're going to hear, it's a murder case, you're going to hear about someone losing their lives. Can't talk to you about the facts of the case, but what kind of witnesses would you imagine hearing from in a case where someone lost their life? Maybe that person's family members, right? That's going to be emotional. You got to be prepared for that. That's going to be tough to listen to. Someone talk about their family member losing their lives. And And it gets emotional for all of us to hear somebody having to go through that, like you, miss. And as a juror, though, I think maybe sometimes that ends up affecting a verdict. And that's just natural because we're emotional human beings, are emotional beings. Some of us more than others. But it's that much more important when those emotions come up in a trial, that you realize that that's what it is and not let it sway the reason, the common sense, the weighing of the facts of the case, and holding the state to that burden. The judge went over the different burdens of proof. There's different standards of proof in the law. The lowest standards would be a scintilla of evidence. That's when something goes up on appeal, and it's going to be upheld on appeal so long as there is a scintilla of evidence supporting one claim or the other complaint. That means any evidence whatsoever. It's a very low burden, a scintilla of evidence. The next level up would be reasonable suspicion. Reasonable suspicion is just what it says. It's for example, an officer, if he sees something that's suspicious to him of some type of criminal activity, he can act upon it. And usually that means pulling somebody over. If he sees traffic stops are based on reasonable suspicion. If he sees a car with a light out, he can pull it over. He has reasonable suspicion that he's committing a traffic offense. Stopping someone walking on the sidewalk to ask for their identification and say, "What are you doing here?" Police can't just stop people on the sidewalk downtown and say, "Hold on a second, what are you walking down this street for? Let me see your ID," and run them for warrants. You can't do that. We have freedom to walk around where we want to walk. Now, if an officer has reasonable suspicion that there's some criminal activity, well, then he can do that. He can stop you and ask you for your ID. For example, let's say that somebody was robbed in a certain area and the ID comes out that it's a male in his 30s wearing a red shirt. Well, I would say that would give him, an officer in that square mile or what have you, reasonable suspicion to stop any male in his 30s in a red shirt and to check him out, and go no further. He wouldn't be able to search someone based on that, on reasonable suspicion. That's when you get to the next level of proof in the law, which is probable cause. Probable cause is more than just reasonable suspicion. It's actually observing some articulable facts, some observable facts that tell you that there's criminal activity or that person is associated with criminal activity. That's what an officer needs to be able to search you, to tell you to empty your pockets, or to get out of the car and search your car. They have to have probable cause. So as y'all can see, it's a gradual increase in the level of proof for different scenarios. The next level is a preponderance of the evidence, as the judge said. That is for civil suits when you're suing somebody, and that's just 51% leaning towards 49% or what have you. In other words, a little bit stronger evidence on one side than the other side. The next level up, as the judge said, is clear and convincing evidence. That is evidence of and I want to get this right, it is a firm belief, clear and convincing evidence. It's the measure or degree of proof that will produce in the mind of the trier of facts a firm belief or conviction as to the truth of the allegation sought to be established. A firm belief or conviction, that's clear and convincing evidence. And as Judge said, that's the evidence that's used in the child CPS cases when CPS is seeing whether a child needs to be removed from the home. But the important fact is that firm belief or conviction for clear and convincing evidence, that is still not beyond a reasonable doubt. So you could have a firm belief or conviction regarding a set of facts or what you feel about an issue, and that's still not enough to find someone guilty beyond a reasonable doubt. Because you can have a firm belief or conviction but still maybe have some doubt, right? You could feel a firm conviction, firm belief or conviction and still have some doubt. In a criminal case, you can't have that doubt. So long as it's reasonable. That's extremely, that's the highest burden that I could imagine anyone ever having for anything. And that's the burden that you will have. That's the state's burden to prove to you before you find someone guilty of a criminal offense. And that's the reasons for that, or going back to why our criminal justice system works. We don't want guilty people going free. We don't want innocent people going to prison. Anyone have questions about those things? Disagreements with it? Feelings one way or the other? Okay. Self-defense. Jason covered some of the things that apply to this, but let me read you what when deadly force is used, there's a justification for using it if the following is met. Deadly force is justified. If someone uses deadly force against anyone else, it's justified when the actor reasonably believes it's necessary to protect himself against the other's use or attempted use of deadly force. And that's it. There's nothing in law about whether that person's running away or what the situation is. It's when the actor, the person who uses deadly force, when he reasonably believes it's necessary to protect himself against the other's use or attempted use of deadly force. Now, this is something that Jason didn't talk about, and it's important. How do you define deadly force? Deadly force is defined as the degree of force that's necessary. No, excuse me. Deadly force is defined as the degree of force that's likely to cause death or serious bodily injury. So the law allows a person, you're justified to use deadly force. Not only if you reasonably believe that someone's going to use deadly force against you or to result in your loss of life, but also cost you serious bodily injury. So, does everyone understand the distinction there?
Yes, sir.
Does anyone have a problem thinking that you could use deadly force if that other person wasn't going to necessarily take your life or kill you, but could cause you serious bodily injury? Anyone have feelings about that? Juror number 7, you kind of, my feelings, you were kind of getting to that when you mentioned if some large man came up to you and you felt was going to physically assault you, you felt that you would be justified in shooting him.
For instance, if someone barged into my home,
Mm-hmm.
where I reside, and they were rushing towards me. I am a small girl. I mean, I'm tall, but small in stature. I would probably get my gun and threaten them.
Okay.
That would probably be it. And then if they actually came and, were on top of me or grabbed me, then I would probably shoot them.
Would they have to be on top of you and grabbing you before you felt that you
Yes.
reasonably believed that you were in danger of serious bodily injury?
Yes.
Okay. I hear some mumbling. Who else has to say anything about that? What about a situation, we can say in your home or not home, where someone, and you see it in their eyes, they're coming at you with their clenched fist and raising that fist towards you, you wouldn't feel comfortable shooting them? You don't think you'd be justified in shooting them? What about yourself, man? How do you feel about that?
Can we have a closed fist?
Yes.
I don't think that warrants being shooting.
Okay. Number 10.
I think the threat of deadly force could be used to de-escalate before going straight into deadly force.
Okay,
That's, I mean, I mean, as a nurse, I mean, like you said, you get threats all the time. I mean.
What do you
don't
mean?
carry handguns, so we have to use de-escalation.
if possible, we want to de-escalate.
Yes.
If, like you, that's what you're saying. If possible, maybe what, throw a warning shot at somebody to just back up,
Not a
right?
warning
A
shot.
verbal
but,
warning, period.
Like.
Verbal
draw
warning.
the weapon and say, I will use this if you continue.
Okay, and what
No,
if they what if they disregard that and continue? And you feel that they're gonna cause you death or serious bodily injury.
Once you've attempted to de-escalate, they are in turn escalating.
Okay, how do you feel about that?
I believe it's verbal. I mean, all you have to say is verbal. If a guy's coming at you and you think he wants to do you harm and you tell him I have a gun, I'm gonna shoot you if you keep coming towards me. If he continues to come towards you, then he obviously intends to harm you. You have a right to defend yourself.
Okay. Yes, sir.
If they have the ability, capability, or intent to harm, you would probably harm.
That's important, the serious bodily injury, not just harm. Yes, sir, go ahead.
Yeah, but if they have the ability, capability, or intent to do serious bodily harm, then I can see how the perception of using a firearm would be justified, but if it's not, that's not the case, then yeah, there is that possibility where it can be de-escalated.
And that's what the law says. I mean, I'm not giving you my opinion. Our law in Texas, again, says the deadly force is justified when the actor reasonably believes it's necessary to protect himself against the other's use of deadly force. And so I guess in y'all's example, maybe you're talking about a situation where you don't necessarily feel that that person is going to kill you.
Right. I would
Right?
probably use my bat that's beside my bed first.
You're gonna try to gradually, before you use deadly force, try to de-escalate. Yes, ma'am. 14.
If, going with what she said, if somebody comes into, bust into my house, I know they're not there for dinner. And I will shoot them.
Let me,
There's no ifs and buts about it.
that you raise another point, and I'll get back to you. What you're talking, when we're talking about in our house,
Yeah,
that used to be an important distinction under the law. And the distinction went to the duty to retreat.
10 minutes.
Yes, Judge, thank you. It used to be the law that you, in your house, when you were deciding whether deadly force was justified, you didn't have to retreat before using deadly force. But out on the street, if this happened walking along the sidewalk in a shopping mall, or anywhere else, you had to retreat, or attempt to retreat before using deadly force. If it was possible to retreat, you had to. That's not the law anymore. So the law is you do not have to retreat so long as you're in that place lawfully. If you're on that sidewalk lawfully, you're not instigating the confrontation, then you don't have a duty to retreat. Someone's going to you reasonably think that they're going to use deadly force against you. You do not have a duty to retreat, even if it's not in your home. Does anyone have a problem with that? Does that just not set well with anyone? Yes, sir.
I mean, this is coming from, like, pretty much any business these days. Like, they will train you on, say, I work in the city and we're trained with the run, hide, fight. And I mean, even if it's not mandated by law, retreat should always be retreat, de-escalate, or just get out of there before you resort to force.
Okay. That's what you feel personally. If you can retreat, you should retreat. If the law tells you you don't have to, and you sit on a case, and again, these are hypotheticals, not necessarily the facts of this case, but if you sit on a jury where the law tells you that the law says you don't have to retreat, and the person didn't retreat, would you have trouble following that law just because personally you think they should have retreated?
I would have trouble coming to a conviction on that, or to a guilty, not guilty.
A justification.
Yeah.
You wouldn't be able to follow that law. Okay, thank you, I appreciate that. Anyone else would have trouble with that issue that a person does not have to retreat so long as all the other conditions of using self-defense, so long as everything else applies? Is everyone else okay that you don't have that duty to retreat in Texas? The other issue in the short time I have left, and I lost the bet because I told Jason I would take less than 30. Yes, sir.
Personally, I don't think that.
Oh, and I'm sorry. So jurors and counsel, if you can just acknowledge the number, so the number can appear on the record for the court reporter.
Yes, Judge, 54.
I think the before should be like the last thing. So I agree with, I don't know. Just
Number 10?
Yes, number 10, that even though legally technically you are not obligated, like you don't have to, but I feel like that should be like your first thing instead of, oh, I'm gonna go, you know,
Sure.
shirt, shoe, or whatever. Just me personally.
Sure, thank you. In your experiences in the emergency room, I'm sure you've seen, how long have you been doing?
7 years.
Okay, I'm sure you've seen a lot of people come in with serious injuries, quote unquote, serious bodily injury. That was not the result of a gunshot wound or a stabbing or something to that effect. Fair to say?
Mostly by gravity, yes.
What?
Gravity, just being pulled, it's a joke, just pulled off a ladder, so that's the majority.
What about thrown off a ladder? Could it happen?
Yeah, actually, I don't think I've seen someone thrown from a ladder, but yes.
Well, just not your personal experiences. Now I'm asking you hypothetically.
Yeah.
Can someone suffer serious bodily injury by being thrown off a ladder?
Oh, absolutely.
How about not on a ladder, just thrown to the ground?
Not as much.
Okay,
Sure.
good, but it's possible.
Some, yes.
Okay,
Not as much as 10 football.
right. But again, I don't want to beat it to death, but you could still suffer bodily injury by just getting thrown to the ground.
Some.
Possibly even your head hits pavement.
Sorry, I'm getting into the specifics of like age groups, but yes, so for some people, yes, they can receive bodily injury just from a ground level fall.
Okay, what about just from a severe pummeling?
Yeah.
Someone just sitting on top of you and just boom, 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 repeated blows to the head. Could that result in serious bodily injury?
It can, although. Are you looking for a detailed answer or just a plain answer? Because
Well, let's start with a plain statement.
using fists doesn't tend to lead us to as many injuries. I've certainly seen more people from ground level falls have like brain bleeds, less than ladders.
Can it?
Fists maybe not as much.
Okay, can it though?
Yeah, I mean, maybe, sure. Not
Yes?
as often, but-
Oh, absolutely.
What about if it's a big guy? A big guy, big 300-pounder beating on a small 100-pounder.
Sure.
That would increase the likelihood, right?
Yes.
Case by case, fact by fact, but the point is that things could happen in all different ways. So people could suffer serious bodily injury. It doesn't have to be by someone coming at you with a knife. If you feel they're going to pick up that knife and finish the job, then you might feel that self-defense is immediately necessary. Fair to say?
Yes, yeah, in the emergency department, sometimes we'll have very, very large dudes that are high on maybe a mixture of different medications or pharmaceuticals that they've taken. And those are definitely the most dangerous individuals we'll have to deal with.
And which is fair to say because they're so unpredictable,
Yes,
they tend to rage
they can.
and they could cause extreme damage to another person.
That's the concern, yes.
Does anyone else have any input about that or any feelings about self-defense or yes, sir?
I'll just say that I was kind of alarmed at your feeling confident when this person broke into your, once they get their hands on you, it's out of your control. And if you're in fear for your life.
No, I realized that, I served in the military, so
for 23
So you're
and a
more
half
confident.
years. So, yes, I am. And I've been in situations in the past where I didn't feel confident. And I will never feel that way again.
I've used up my time. Does anyone have any questions or comments? Thank you all very much.
All right, ladies and gentlemen, I'm gonna have you all step outside, but before everybody rush to the door. Everyone who's in the box, you need to take your items, your personal items, and everyone here in the audience this way, if you'll take your personal items with you as well, and please leave behind the expensive number cards. All right, so if you'll wait outside for us and we'll call you back in later. All right, everyone, please rise. All right. So first I'm going to put on the record the numbers that you all have agreed to. 1, 2, 4, 8. Number 12 was excused. You've agreed also to 15, 16, 19, 22, 24, 34, 38, 40, 41, 46, 48, 62, 64, and 71. Were those agreed to, state?
Yes, Your Honor.
Defense?
Yes, Judge.
And so that the record could be clear, number 12 was an agreed excused. Is that correct, state?
Yes, Your Honor.
Defense?
Yes.
All right, these are the persons who will be on the panel. Number 3, 9, 11, 18, 23, 25, 26, 27, 32, 36, 37, 39. Any objection, state?
No, Your Honor.
Defense, any objection?
No.
The alternates will be number 49 and 51. Any objection, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, and just so both parties are aware, I don't let the jurors know that they're alternates because I want them to be actively listening to everything. All right, everyone, please rise and let's bring the jurors in.
Do we go to the other side yet?
Yes,
Yes.
yes.
Hey, you want us to switch?
Yes, if you want to.
Hurry up so they won't see you then. Over here.
We can say that.
Oh, I'm sorry. Sit down.
We do this.
No, no.
Whoever you see this.
And everyone, you'll see white paper on the benches. Just take only one.
No. Here. To finish, all the way to the edge. The diary can hand.
Put it back down. All right, we'll put it back down.
All right, everyone, please be seated. All right, ladies and gentlemen, I want to thank you for your service. Again, I truly do mean it when I say that we cannot have jury trials without jurors. And this is one of the things that your country asks of you. You all should have a white sheet of paper. If you do not, Deputy Mahia, who is right behind you, who you can't see, has some extra. Those papers will signify that you have actually been in service today. You're always welcome to come to the 187 District Court. It's open to the public. All the courtrooms are open to the public, but I discourage people from going to juvenile court or child protective services court because those are extremely sensitive matters that are dealing with juveniles. I'm going to call the name of the jurors who will be on the panel. And so when I call your name, please take a seat. Mario Rivera. Alex Luvana. Ryan Snodgrass. Fernando Menchaca. Stephanie Padilla. Bobby Gonzalez. Royal Perez. Royal Pettis. Jasmine Paniagua. Alfred Lozano. Laura Alvarez. Rodolfo Salinas. Jorge Rangel. Jennifer Cowan. Joseph Shaw. All right, so everyone, for your service, you will receive a fee. You can do one or two things. Oh, if you'll just take a seat up here. I'm sorry, Joseph Shaw. All right, and you are Jennifer Cowan? Thank you. All right, so you will receive a fee for your service here. You can do one or two things. One, you can donate it, and there are plenty of organizations that you can donate it to down in the basement in the central jury room. They actually have a list of different charities that you can donate it to. Or you can keep it. What will end up happening probably 3 months from now, you'll receive a check in the mail and you will wonder, is this real? Where is this coming from? Then you'll remember the great time you had with Judge Boyd in the 187th, and you'll be like, this is real. So thank you again for your service, and you all are excused.
Because it might, what happens is that the way it's printed, it doesn't catch everybody.
Well, since I do have two last names too, so it's extra long.
That's probably why.
So it's like you're my first last name, I'm like, I know it's me.
Oh, it's you.
I hear a little, and I'm like, "It's me."
That's probably what it is, that your whole name is so long that it.
That's off my first name.
Yes.
Yes. Yeah. Okay, everything's good.
Thank you. You're missing out.
All right, everyone, you may be seated. All right, ladies and gentlemen, I'm going to give you some instructions. The first thing about this courtroom, sometimes, well, not sometimes, the majority of the time it's extremely hot in here. I have no control over the heat. There's a thermostat that's on the wall, but it's just a placebo. It doesn't do anything. You are allowed to bring drinks in. Just make sure there's a cap or something on them to avoid spillage. If you ever need to have a break, just do the break symbol. Either I will see it or the deputy will see it, or some of the attorneys may see it and they'll let me know. When you come tomorrow, you will not be reporting inside this courtroom. You'll actually be reporting to the jury room, and Deputy Laura will show you where that jury room is. I don't expect any publicity in this case, but you never know what may end up happening. Sometimes cases take a life of their own. You're not allowed to discuss, investigate. Everything that you need to know about this case is to come from inside this courtroom. That way the state and the defense both will have a fair trial. Does everyone understand? So don't do your own investigation. Don't Google names or go to social media or any of that. If you see anything about this case, you are to ignore it. Tomorrow you will be given, or Deputy Laura may give you badges now, but the badges will signify that you're jurors in the 187 District Court. Whenever you're in the courthouse or even walking around downtown, just make sure those badges are visibly displayed, because sometimes state's attorneys, defense attorneys, they'll be talking about cases. And if they see you, they'll realize that you're a juror and they won't talk about those things. Are there any questions? Yes.
Just on the drinks again, are we able to bring like our own cups, or do they have
Yes.
to be like bottled?
Oh, no, you can bring your own
Okay.
cups. The other thing is, there is a refrigerator in back in the jury room. So if you want to bring your lunch for the day, you're more than welcome to do that. Or if you want to bring whatever and it needs to be refrigerated, we do have a refrigerator for you. I know the seats are hard. We've been slowly buying cushions. So there are cushions in the back and you can bring them with you. I don't think we're at the point where we have 14 yet, but so first come, first serve. You're more than welcome to bring those. We're going to start tomorrow at 9:15. Here's the thing. There are a lot of jurors who are called up every single day. So the parking garage gets full. So not only do we have every single juror, everybody who works in this building parks at the parking garage. So it's best that you get here early so you'll have a space. Now, what I can tell you is when they call jurors to come down, you all know this, they tell you to be here at 8. So if you come at 8, the deputies will be here. I will be here. There will be someone to open the jury room for you. So if you want to come at 8, get your lunch or get your breakfast, you can always go downstairs to the cafeteria to get breakfast and you can bring it back up to the jury room, but do not report in the courtroom. And we're starting at 9:15 because I have other cases that I need to take care of, but it should be very short. That's why I say start at 9:15. And you had a question.
For work, like, are we gonna get like a form or something? I've never done this before, so I
Oh,
don't know.
no, you'll get a form. And if there's any issue with anybody's employment or somebody's telling you something, just let the deputy know and they can know that they can call the court and we'll let them know that you're here. Okay. Yes.
For the parking garage, are we gonna be validated?
Yes. And if any reason you're leaving late, like downstairs, they may have closed off the central jury room. When you leave from the parking garage, just let them know that you're a juror in the 187 District Court and they will automatically validate you. Yes.
Is it gonna just be for tomorrow or is it gonna go through the whole week?
It's going to last longer than just tomorrow, but we'll find out. Okay. Any other questions? Yes.
Can you report to the original jury room tomorrow?
No. You're going to come up here and Deputy Laura is going to show you where you report.
No, I'm
Yeah,
gonna show you.
she's gonna show you.
I'm gonna show you.
Yes. So, but whatever you do tomorrow, when you come, don't come inside the courtroom. She's going to show you where you come. All right. Any other questions? I am sorry that you're going to get hit with rush hour traffic today. Usually I try to end so you're not hit with rush hour traffic. Yes.
Got one more question.
Yes.
What if we have an appointment Thursday?
When is your appointment on Thursday?
10 o'clock,
And what is your appointment for?
property closing.
Okay. All right. Well, what I can tell everyone on Thursday, you're going to start at 1:30. All right. So Wednesday, which is tomorrow, you'll start at 9:15. And on Thursday, you're going to start at 1:30. Here's the thing about starting on Thursday at 1:30. Usually people will go, I call it going off campus for lunch. So if you can get that sweet spot of arriving in here by 11:45 or 12, you'll probably be able to get parking space at the garage. Anything else? All right, then I am going to release you to Deputy Laura.